Hi, everybody. Welcome to Community Conversations. I'm very pleased that our series is able to both allow for an in-person audience as well as our audience on Zoom. So shout out to all the Zoom people right now. Welcome. We will be monitoring the questions there. So if you have a question over the course of the presentation here, please feel free to put that into the chat and we will present that to the speaker at the end. And also, please come back next week in whatever format you want to come back. We have Annette Ward from the nursing department, who's going to talk about lifelong health in a talk entitled, I love this, Live Long and Prosper. But today I want to welcome back one of our speakers that started to do these more often now, which makes me very happy, Anita Quirk. Anita Quirk's undergraduate degree was Spanish with a religion minor, but her graduate degree is in law, and she was in private practice attorney for 21.5 years, also practicing in the area of estate planning, probate, and guardianships. She provided continuing legal education seminar for certified professional guardians and attorneys for many years, and she has been teaching at LCC since 2011 and now teaches criminal justice and business law classes. Please welcome Anita Quirk.
Thank you everyone for coming. Because these subjects are really very, very complicated, I'm only going to be skimming. I think I'm off here. Yeah. There, is that better? All right. So as I was saying, these subjects are very, very complicated. And so I'm just going to be skimming the surface and giving you some general information today. So first, with estate planning, the first thing we usually think about are wills. And of course, that's going to be the basic document that we would use. Now, under state law here in Washington State, a person needs to be 18 years old and have sound mind, so 18 and above. And what we call sound mind is that the person knows basically what they own, they know who the potential heirs are going to be, and really that's where we start. Now, one thing in both Washington and Oregon, neither one of these states will accept what we call a holographic will. These are handwritten, normally not witnessed wills. And the reason for this is because on a person's deathbed, or even prior to that, someone can pressure them to make a will and have that person as the beneficiary of that will. And so the state legislature said, we don't want that to happen. So we have to go through formalities with wills. So we type them all up. We have them witnessed by at least 2 witnesses that they themselves have to be of sound mind. And they're stating that the testator, if it's a man, or the testatrix, who is a woman, is of also sound mind, and they understand what they are signing. Okay, so that's the gist of it. Without those kinds of formalities, we may not have a valid will. Now, if a person does not have a written will and that person passes away, we say that that person died intestate. This means that the person's estate now will go under the statutory scheme of the state and not necessarily how that person really wants it to go. So having a will in place that allows the person some control over who will actually benefit under the estate. Now, one thing that I've often find is that we tend to underestimate the value of our estates. So a lot of times I've had people say, well, I don't need a will, I really don't own anything. Well, assets aren't just those tangible things that we can see and feel, vehicles, houses, furniture in our homes, those kinds of things. Our estates are also made up of intangible things, such as retirement accounts, bank accounts, life insurance policies, anything of that nature in which we have an ownership interest are our assets. And if you start adding up the value of all of these things that you own, you may be very, very surprised at the extent of what your estate actually is. Now, of course, when we're taking a look at that, one of the things we have to watch is, do we need estate tax planning? Now, currently at the federal level for federal estate taxes, you have an exemption value of 11.7 million, which means you can give away whatever you have in your estate up to that value, whether it's lifetime gifting exemptions or after one passes. I'm hearing rumors that that might be cut in about half though, so we'll see what the legislature does for 2022. Here in Washington State, we actually have also estate taxes, but you have an exemption of, it's over 2 million at this point. So you notice it's quite a bit lower. We used to keep up with the federal rate, but the federal rate just kept going higher and higher. And so Washington, we're cut off at a bit over 2 million. Now, a lot of people want to not have to probate. For some reason, we've got a lot of people wanting to avoid probate, but probate actually has a lot of safeguards in it. First of all, it is passing title. That's the whole idea. In probate assets to whomever we've named as heirs in the will, or if we don't have a will, however the state says they'll go. Probate also helps protect the beneficiaries from possible creditors, creditors that we may not even know. Because during the probate process, creditors need to file claims. Now in the probate process, we have someone who, if we have a will, may be nominated in the will to act as what we call our personal representative. If there's a will, we might hear the term executor. If there's no will, that person is called an administrator. The one great thing then is that the personal representative is going to be able to gather the assets. Ultimately, we'll end up dispersing those assets, but creditors then get paid on the claims that they file. And if for some reason, because we publish literally in the newspaper, that if there are any unknown creditors, that they need to file a claim within a certain time period, and if they don't, then their rights would then be cut. If we know who the creditors are, well, we usually end up just paying them anyway, because we know they're there. One instrument that can be used to avoid probate is what we call a trust. There are many kinds of trusts. And they can be a little bit complicated, but they're very useful for a lot of different purposes. The downside with trusts, and I would periodically see this happen, where a person has passed away, we call that person the decedent, and that decedent had a trust. And so the family members, they bring that trust document in. And my first question is, was the trust funded? The trust doesn't do anything for us unless the trust owns all of the assets. If it owns all of the assets, the beneficiary within the trust will then take the estate. Now that does not cut off creditors, and it also does not cut off possible estate taxes. It just avoids a probate, okay? One of the saddest things I would have to tell people when they say, no, the trust doesn't own the person's assets was, we're going to probate. Unfortunately, some of these trusts are very expensive to set up. Way back in the day, they were like $1,200. They're more expensive now. So basically, in those days, $1,200 pieces of paper that had no function. Another document that actually is something we would use while we are alive is called the power of attorney. Now, anybody can be an attorney, in fact, under a power of attorney, if we're nominated to be so. I'm sorry about that. The word attorney means representative. So for instance, when I was in law practice, I was an attorney in law, so I could represent other people. Same under a power of attorney, the attorney, in fact, acts for the, in the stead of, and for the benefit of the person who is granted that power. Now, powers of attorney can be used for all different kinds of things, and they can be very, very narrow. For instance, allowing someone to sign, say, real estate sales documents for us, or they can be very, very broad. When we're talking about estate planning, we're talking about what we call a durable power of attorney. These usually will have a specific thing that has to happen before they can even be used. And usually, this is usually when we get the person's doctor involved, where the doctor may say, yes, this person needs his or her affairs looked after because he or she just can't anymore. The reason why they have to be durable is because the regular powers of attorney, if the person becomes incapacitated, will no longer be in effect. So the durable power of attorney is really what we need. Now, we always hope we never need them, right? We always hope we can always take care of our own affairs. But having one of these set up at least allows us the opportunity to nominate someone we trust to take care of our affairs for us. Now, these are only good while we're alive. Once we pass, then the will takes over. Now, what if we don't have a durable power of attorney and we actually become incapacitated? At this point, we have to move into formal guardianship proceedings, which means normally continuing court oversight at regular intervals. Now, we can have a guardian of the person, which would make sure that the person is being cared for, and a guardian of the estate. These could actually be two different entities. Oftentimes, though, we end up with a complete guardianship where we will have person and estate combined in one person. But we still have to have court oversight. So a good durable power of attorney can actually keep us from going into these guardianship proceedings, again, if enough powers are given within that document. I periodically would have people come into my office who they've been helping one of their relatives who now has been put into a nursing home. And they would come to see me about a power of attorney. Of course, my first question would be, can your relative understand signing legal documents? Usually the answer was no, this person has dementia. And then I would have to give them the sad news at that point, I cannot give you that power. Your next step is formal guardianship. Now, sometimes guardianships can be temporary. I was very happy to be guardian ad litem on a couple of cases where that actually occurred. Because of more medical treatment, the people were actually able to start taking care of their own affairs again. So then I would be reappointed, reinvestigate the case, and make the recommendation to the court that this person no longer needs a guardianship. So, but that was only 2 over the many years that I practiced. So this guardian ad litem is a person appointed by the court to investigate the case and make recommendations as to whether or not a guardianship is needed, what the extent of that guardianship should be. Because these are very, very serious. In a guardianship, the person is deemed incapacitated, which means this person can lose a lot of rights that we actually enjoy. And so it's not the kind of thing that we want to have put in place if the person truly can still take care of his or her own affairs, maybe with just a little extra help. And if the person is capable of understanding signing any kind of documents, that person can maybe go ahead and sign a power of attorney, and then we can put an attorney in fact in place. We've reserved and we've conserved all of the rights. That's a basic quick rundown. So it took a little less time. Now, the one thing I do need to let you know is this actually is truly quite complicated, and every one of you, your estate is different. So what is my recommendation? A consultation with an estate planning attorney. That doesn't mean you have to hire an attorney if you go get a consultation. It probably will cost you a little bit. But an estate planning attorney with knowledge about your income, your assets, your heirs, if you decide you don't want anybody to take under your estate, any of those kinds of things, you will gain the knowledge that you will need. You may just need a will. Maybe you own a piece of real estate outside of the state and you want to hang on to that. Well, Washington state does not have jurisdiction over real estate in another state. So you'd have to go there, or your personal representative would have to go there and probate it in that state. And some states, probate costs are really high. They're not so bad here because we work hourly, and if states go well, it can be relatively inexpensive. In fact, one of the most inexpensive estates on which I was an attorney for the personal representative was an estate in excess of $1 million. That's because people weren't fighting. Everything was in place. And my time input didn't have to be that much, strangely, even though it was the largest estate. Conversely, if we don't have a will, the estates are more expensive to administer. And if all the heirs decide they want to fight, the only people who win are the attorneys. And unfortunately, I've seen some estates, that's exactly what happened. All of the monies went to pay court costs and attorneys. And it could have been completely avoided if they had decided to stop fighting. So the more kinds of these things we can get set in place so that people know our wishes, because just verbally saying, unfortunately, is not going to help in probate. Usually the administration of the probate process tends to go smoother. Can't always guarantee it, but it tends to. Okay, does anyone have any questions?
I definitely do. I'm going to jump in first because
Oh.
I'm in charge and I get to make these decisions. So last year, you know, because it's 2020 and everything is on fire, I decided, hey, it's time to make a will. And so I went through this process. And one of the things that my lawyer that I consulted with about this mentioned was, oh, yes, you're divorced. You're going to want to make sure that this is very clear that, you know, when the kids are minors, they might have their father as representative on financial things, but once they are 18, you don't want him to be able to access any of the other stuff. And so going through, what is it like now? What's it going to be like 10 years from now? What's it going to be like 20 years from now? You know, as I'm in my 40s. And so, you know, thinking not just about the here and now, but also what is, you know, what is in the future. It was very helpful to kind of go through that, and it wasn't that expensive. And so it really did sort of outline to me the various steps along the way to make the process as smooth as possible if and when something, knock on wood, happens. Okay, I've got 2 kids, it's going to be 50-50, and this is the way they're doing. And that was really helpful for me, for peace of mind as well, to know, okay, this is handled and I know what the situation is going to be. So just endorsing the idea of getting a consultation
Yes.
is now I'm going to allow other people to actually ask questions.
So yes, if anyone has minor children in particular, if you're not considering what might happen potentially, and we always hope nothing ever happens, right? But if something does happen to us and we have minor children, who will be the guardian of those children? You know, what is your situation? Children should not, who are underage, should not just inherit outright. We usually set up trust provisions within wills where we will have a testamentary trust set up, which means it flows out of the will. So then we have that set up with a guardian, trustee for that trust, all of those things, and we can nominate all those people within our wills. Oh, testamentary. Yeah, that means we don't necessarily, that means we don't set up the trust ahead of time. The will actually puts it into place. If we have either children or other family members that will be heirs who are incapacitated in some manner, we want to make sure, especially if they are going to be able to get extra services and state aid and those kinds of things, we want to make sure that that all gets set up properly, because otherwise it can really mess up their financial futures. Yes.
Okay, I have property in another state.
Mhm.
So does that mean that I have to make a separate will? Or do I need to go to a lawyer in that other state?
Oh, no, not necessarily. If you were to pass away, that piece of property would have to be probated in the other state, although we can get around that with a specific kind of trust. Because under trusts, we name beneficiaries who will take the trust assets, which is why we don't have to probate them. They just flow over to those beneficiaries. So you'd want to talk to an experienced estate planning attorney and talk about any properties you have elsewhere also, so that you can look at whether or not it's worth your while to set up some kind of a trust. Yeah, because unfortunately, probate in some of these other states is a lot more expensive than here, too, because I think California, New York, and Texas are the big 3 that I can think of. And plus the fact, like I said, even if you nominate a personal representative under your will here, your will is probably still good in another state. It's just Washington state won't have jurisdiction over that real estate that's outside of the state.
So if I have a will already here, it's best for me to also get a trust for that other property?
Potentially, yes. And so my recommendation is to speak with an estate planning attorney and let that attorney know that you're planning on keeping that piece of real estate. And so what can you do so that you won't have to have it probated outside the state?
Well, something I didn't know. Thank you.
Oh, there's a lot of wonderful things out there. Unfortunately, I literally could teach a whole quarter just on estate planning. So there's so much there. Yes.
Yeah, and keep in mind, we're keeping it 101 here, so yeah. Anita is not our lawyer. None of us have that
No.
privilege, but she can definitely say, hey, you might want to talk to one.
Exactly.
So when you're gifting to charity, is there a minimum or a maximum or something, stipulations a la Washington law that gives you guidance, as it were?
Oh, if you're planning to leave anything to charities, oh, that's a whole nother subject, which is actually a wonderful subject. Sorry, I get a little excited over this stuff. The one thing to always know is whatever you have an interest in, you may leave to whomever you choose, but you do have to disinherit anybody who's a close family member if you don't want them. Okay, so that was just a little aside. No, you can leave charities pretty much as much as you want. We have specific charitable trusts that one can set up. And so depending upon what you might want to do, you might even want to talk to, for instance, like OPB actually has someone specifically you could talk to about setting up like a charitable trust where they are the beneficiary of that trust. The one good thing also about setting up charitable trusts is we do have tax planning advantages to those. But again, everyone's estate is different, value of assets, where we really want them to go. You can leave all your assets to your cat if you want. So you get to do, it's yours. Now remember, we are not heirs to the living. So everything that is yours now is yours. If you want to use it all and go on a round the world trip, whatever you want to do, it's yours. Okay? So if you ever hear somebody saying, my mother's spending my inheritance, guess what? You do not have an inheritance until she passes. That's when we know who the heirs are.
Mhm. So so what you're saying is if you wanted to give the whole thing to charity, you have to disinherit your heirs. And you just do
Yes.
that with one sentence, or is it a whole long paragraph of details?
Yeah, we usually have a paragraph within the will
Okay.
that says, I'm leaving this person nothing. Now, I actually have 2 people disinherited in my will. And what I have done is basically actually given also the reason
You have to give a
why
reason?
those people
Wait,
are
wait.
not to receive.
Have to give a reason? You
No,
don't?
you do not.
Okay.
No. And another thing, a lot of people think that you have to give them at least $1. No, you don't have to give them anything.
Oh, okay.
Yeah.
Next question. Can you make funds available to the next generation past your grandchildren?
Oh, yes, we have a number of different ways to actually do that. You can do that, for instance, where we have certain contingency beneficiaries. We can do that within the will. Sometimes we will set up specific kinds of trusts to actually do that. So depending on your situation, again, I would talk with an experienced estate planning attorney and say, okay, here's my situation. This is what I want to do. And then that attorney will be able to say, okay, this will be the best way for you to have that pass the way you want it.
Okay, well, this is
Yeah.
sort of like hypothetical, right? So let's say you have a grandchild and you presume or hope that that grandchild will have a progeny. But so you could say, you know, if there's nobody born in 25 years, then the money will do something different. Is that a
Mhm,
correct statement? Okay.
Yes, yes, you can set up certain kinds of contingencies. Now, one thing that no state in the entire union will allow us past just so many generations to be able to continue to control it, is the thing. But yes, we have ways where we can pass things on to other generations. Mhm.
Okay, we have a question coming in. We have a question coming in from Zoom. Adam wants to know, how often should someone re-examine their will?
Great question. Usually I recommend once you get this set up, this is exactly what you want. There are certain things in life that happen. Births of children, adoptions, marriage, divorce. Anytime we have a major thing occur, we should go ahead and take a look again back at our estate plan. Also, if it turns out that it appears that our estate, and again, this, remember, it's the value of anything in which you have an interest, that's your estate. And so if your estate starts getting large enough, you may want to consider some estate tax planning. And remember, the Washington level is much lower currently than the federal. So that's the one we want to keep in mind. So if your estate looks like it is getting to the point of 2 million, you definitely want to start looking at estate planning. So yes, anytime anything big happens, or anytime you're thinking, maybe I really don't want that person to get that, that's the time to go back and take a look at everything.
Thank you. It's very interesting to kind of look at this, you know, as a historian, I've read old probate court records and wills from like the 1600s and stuff like that, and going to the idea of disinheriting people from your family who might be your direct heirs. And often people in the 1600s were very explicit about why they were disinheriting somebody or putting conditions onto it saying, yes, my son will inherit the farm if and only if he marries the person that I want him to marry, and very, very, very specific legal language in there. So it's interesting to see that those sort of stipulations can still be, you know, that's a legal inheritance that we still have in the system today. Okay, I think I saw Sean had a question. Let me get you the mic.
Oh, yeah, I got another. So, yeah, like an example, like Gloria Vanderbilt in that situation that happened.
Mhm.
So I guess that would be a really great example about, you know, and who the heirs are going to be, like Anderson Cooper. If there was ever additional money out there somewhere flying around, you know, what would happen with that? Also, so any major life event that takes place in a person's life, that's when you need to update your will.
Yes, because one of the things we always have to remember, if we have close relatives, so spouses, children, maybe even grandchildren, if we leave them out, because this is exactly what it'll look like, then that person, even though we don't want them to take anything under our estate, the court is going to say, well, this person gets whatever share he or she would get under the state statutes. And so any big life event, you should go back and say, okay, does this still cover what I want? Is this still going to take care of what I need? One of the major big life events, of course, is the adoption or birth of a young child. And now at that point, we might need some kind of testamentary trust. We might want to nominate a guardian, you know, all of those kinds of things. Now, remember, you know, for instance, in my estate planning documents, I have my husband who will take my entire estate. But what should happen? Let's say we're on a trip and something happens to both of us at the same time. I have contingent beneficiaries, okay? So in the event that this happens, then these people will be able to take. With my very first will that I did, I had named my, excuse me, personal representative and 3 alternates. And I realized one day I was taking a plane trip literally across the country with my 3 alternates. So if something should have happened to all of us, fortunately my personal representative was still here, but there's the possibility that we could find ourselves in this situation where anybody would be able to say, oh, I'll be personal representative. And somebody doesn't say, this person is not a good fit. At that point, we might have somebody administering our estate that we would never have nominated. So it doesn't hurt, number one, to have contingent beneficiaries just in case, and to also name more than one personal representative, because you should be able to control what you want to have happen.
And then another thing too,
Mhm.
special power of attorney applied to anything. And then for some of us, in the military,
Mhm.
and that having a JAG representative, I know we've had to deal with wills, power of attorneys, special power of attorneys. And does that representative, the JAG representative, could be interstate, meaning you don't have to go to that state to get something,
Yes, this will go under military rules.
Uh-huh.
Okay, and I do not deal or have not dealt as much with military rules.
Uh-huh.
One thing to always remember is usually wherever we set up certain kinds of estate documents, whether it's powers of attorney, whether it's where we write the will, those things will be written pursuant to the laws in that state. It does not mean that they are not good someplace else. And in fact, I can't think of any states they'll say, well, that's a Washington will, so you're just intestate here if you move to someplace else. I don't know of any state that would do that. So again, how we write them goes under the state rules, but they're usually going to be just fine in another state.
So the key is specifics. Be very specific.
Yes,
Got it.
yes,
Thank you.
you're welcome.
Okay.
Yes,
I just wanted to make a suggestion, so if there's a special life event, you would be the time to check in on your choices for your posterity of whatever. Anyway, I always look at mine every single time I file my income tax, because that's a life event. Yeah.
Yes. Not everybody wants to do that though. So that's why I said any major life event, that is definitely the time to do it. Oh yeah, no, I look at mine periodically. I'm making a few more changes, so.
So I had a question here. We're going to veer slightly off track. When you had proposed this topic was in the midst of the Free Britney movement. And it was at a time, and I think much of this has been resolved, but not all of it yet, this idea of somebody going into a situation where they are considered incapacitated, like Britney Spears, and her father then takes it upon himself as next of kin to take over her guardianship. And that involved not just the handling of her financial estate, but also determining contraception and whether she could get engaged and eventually married. She was not able to do that without his permission. And so it sort of speaks to how big this can be and how this can often come out of, a situation of an otherwise healthy young woman who is living her own life and then has a setback and then is sort of thrust into a legal situation that may or may not be in her best interest. Is that something that I mean, granted, we don't have Brittany's money. I'm assuming nobody in this room has Brittany's money, but is that something that even younger people and generally, knock on wood, healthy people should consider having a power of attorney or something like that, just for the unforeseeable?
Yes, actually, I usually recommend that anyone over the age of 18 have a power of attorney in place. And again, we hope we never have to use those, but in the event, at least we've nominated someone that we can trust. And you can nominate more than one person under that too. If someone is unable or unwilling to act in that capacity, you can nominate more than one, but at least that way you have control, someone that you can trust. Frankly, the Britney Spears case, I do not know what all happened to her that precipitated this. And of course, it's under California law. The powers, first of all, that were granted to her father were well beyond the vast majority of powers that are ever granted to anyone. And frankly, just from the little bit I know, frankly, I'm surprised it even happened. So let me illustrate just a small thing. I was guardian ad litem on a case where a lady had lost her husband and she went on a spending spree. And, you know, she had a few issues, but what precipitated someone in filing the guardianship was she decided to start spending her money. So we have some family members who are saying, she's crazy and she's not taking care of herself and she's frittering away all her money and she's going dancing and she's doing these things. And after I interviewed her and talked to other people, of course, because that's part of the investigation, you know, we want to get all the information we can, I actually recommended to the court not to put the guardianship in place. Well, the children weren't happy about that because basically at this point, they were wanting to control what she had, really. And so just because someone starts spending their money and doing these other things, now, of course, Brittany did have other issues, okay? But that's part of the problem we sometimes see is we will have family members filing guardianships because really they are wanting to control ultimately what they are going to get from their relative. And that's why we have the guardians ad litem to go out and investigate and try to ferret the truth out, you know. But like I said, I was a little surprised, you know, if something were to happen to me and I felt I needed mental health, and so I would go into a facility, idea coming back out, I suspect my relatives are not going to file a guardianship on me. Now, if I'm harming myself, I mean really harming myself, or I've suddenly become homicidal, now that's a different story, all right? Again, we have to be so careful with the guardianships because we are stripping a lot of rights away. And the powers that that man had, I was really surprised. But it is true, we can keep the person from marrying. We can keep them from a lot of things, depending upon what the court order grants.
Thank you.
Mhm.
Oh,
Yes.
one more question.
Yeah, going to that, does the state or even another country, do they have like an age limit? Like, okay, so Brittany, I don't know if they got renewed or whatever, but I guarantee when she was a child, that got written up.
Mhm.
It's just that when she turned 21, 18, 21, that it's still applied in that just because of the specifics in it.
Yes, and so when a
Anyway, I'm sorry,
Oh.
could there be any way of like having the state give a legal notification to the family or that actual person that now is your time to decide, do you want to continue this or not? Would that be a good idea? If there's no
Yes.
medical or, you know, like one's going to harm oneself because of medical reason or what have you.
Yeah, because that would definitely be a reason maybe to keep that guardianship. You have to remember though, even when we have guardianships, we usually can't force people to do certain things. So for instance, unless we have a court order, we can't say you have to take your antipsychotic meds.
What I'm saying is that state at a certain time,
Mhm.
the actual person bringing something to the court.
Right.
They send a legal notice to both parties that this person has the opportunity, unless there's something medically wrong with it, that they're harm themselves, that they need to get this changed or approved as.
She was not under a guardianship as a minor, though. She had business
Right.
management. But when she was a
Right.
minor, she was, I mean, that was before the
I don't know.
the break, yeah.
Wills or whatever, but it's like they were just going off of what was originally, written, and just kept moving on with it, before we really looked at it. But what I'm trying to say is,
Mhm.
would it be a good idea, maybe at a federal level, have each state say, hey, look, at this age, this official notice is sent to both parties. Take this document, or change. It's that important.
While she was under the age of 18, she was already under the purview of her parents. We don't have a guardianship in place. Once a person turns 18, now that person is deemed an adult. And at that point, that's when a guardianship proceeding will actually go into place if it is warranted. So again, minor children, unless there's what we call a guardianship because it's not their parents, it's somebody else taking guardianship. This kind of guardianship that Brittany was under did not go into effect until after she was already an adult. Up until the point she turned 18, she was a child.
So in the original document, it says that, okay, she takes it, but now, even as adults, I still have a guardianship.
You can't just declare that. You have to file formal guardianship or conservatorship, as some states have. You have to file that formally and the court puts orders in place. But that's only after a person becomes an adult.
And only in cases of incapacitation, as you said, with like an investigation, right?
Correct.
Okay.
Yeah, correct.
All right. Well, I think we have covered our bases here and we've hit our limit. So I want to thank everybody for coming and thank Anita for sharing her knowledge with us. And please come back again next week.
Thank you so much.